Okay, so we've got a fresh Karl Lentz method failure out of Corpus Christi, Texas. This is Woman and Man, Vane L. Eli v. Libby. It's Civil Action 216, blah, blah, blah. A little background here. Vanessa and Elias are being charged by the FDA for selling mislabeled pills. I've discussed their case in another video. Today, we found out the result of their Karl Lentz claim against the FDA, and it did not go well. Their case against Special Agent Miller and other FDA agents was dismissed. Quote, the court, having reviewed the pleadings on file herein and hearing the arguments of counsel for federal defendants and plaintiffs appearing pro se, finds that the motion to dismiss should be granted. The court further finds that plaintiffs' claims against the United States should be dismissed. Background. On June 6, 2016, the woman and man, Vanessa and Eli plaintiffs, filed their original petition in the 148th District Court of Harris County, Texas, case number 2016, blah, blah, docket number 1, notice of removal, attachment number 6, blah, blah. Just as an aside, Karl has been helping these people since at least June 6, 2016. I spoke to her. She said that she visited Karl in Virginia. Karl also was down in Texas helping her last week, and he posted the video up on his YouTube channel. Back to the text. The plaintiff's original petition is actually entitled Claim of Notice. It identifies the plaintiffs as a woman, Vanessa/Eli, prosecutors. Plaintiffs did not include their names in the state court petition. Plaintiffs did not sign the state court petition with their legal names, only Vanessa/Eli. In fact, the plaintiffs' names are Vanessa Gonzalez and Elias Trevino. Docket number 4, notice of redacted state court file, attachment number 1, defendants Exhibit C, application for search warrant and affidavit. The petition names the federal defendants as wrongdoers and describes the nature of the case as a claim. This is classic Karl Lentz theory. He claims that if you just call your case a claim, you can win. Anyways, the petition further states claim, trespass, brackets, violation of rights, and I, a woo, brackets, man, claim, the said wrongdoers trespass upon my property. The trespass did and does harm and injury to my property and rights. I, in lowercase, require compensation for the trespass of my property and violation of my rights. Compensation due, all uppercase letters, $100 million. The original petition was served on Special Agent Thorpe and Special Agent Miller on August 16, 2016, and on Judge Libby on August 18, 2016. On September 2nd, 2016, the federal defendants removed the lawsuit from state court to federal court. Just as an aside, this is important because I can't check Texas state court records, but federal court is all online. So this is good for me. The plaintiffs are under criminal investigation by the United States Attorney's Office for the Southern District of Texas and the U.S. Food and Drug Administration, the FDA. The Assistant U.S. Attorney in charge of the investigation is Special Agent Thorpe. Pursuant to the investigation, Special Agent Miller submitted an application for a search warrant and affidavit to the court to search the premises of 2 stores located in Corpus Christi, Texas, operating under the commercial business name X20, which is owned by the plaintiffs. Special Agent Miller stated in his affidavit that there is probable cause to believe that Vanessa Gonzalez and Elias Trevino, doing business as X20, have violated the Federal Food, Drug, and Cosmetic Act by selling products marketed as dietary supplements that are actually drugs, some of which pose dangerous health risks. Docket number 4, blah, blah, blah. On October 28th, 2015, Judge Libby signed the application and authorized a search warrant. The premises were subsequently searched and items were seized. The investigation continues, blah, blah, blah. On December 8th, 2016, the court conducted the initial pretrial conference in this case. The federal defendants were represented by Keith Edward Wyatt, Assistant U.S. Attorney. Plaintiffs appeared pro se. At the hearing, plaintiffs refused to identify themselves on the record despite being repeatedly asked to state their names. Plaintiffs were given numerous opportunities to explain the nature of their cause of action, but continued to answer unintelligibly with statements such as, "I am an idiot in legalese," and "apples, oranges, bananas." Plaintiffs refused to describe the property they alleged was seized. Plaintiffs then asked for a continuance to obtain counsel and asked the court to appoint counsel. The court offered informa pauperis forms for plaintiffs to fill out that so they don't have to pay the filing fees, but they declined. The plaintiffs also refused to apprise the court of their efforts to obtain counsel, probably because the counsel they were trying to obtain was Karl Lentz, who was not an attorney. As further discussed below, the individual federal defendants in the case of Barr were acting within the scope of their employment at all relevant times, and therefore the court dismisses the claims against individual federal defendants at the initial federal blah 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 pre-conference. Moving on, plaintiff's original petition is very difficult, if not impossible, to understand. Although plaintiffs were given ample opportunity at the hearing to explain their cause of action, they refused. Plaintiffs appear to be complaining about the search of their premises and items being seized. But the plaintiffs are demanding $100 million in damages. Their claims sound in tort, i.e. trespass, and are therefore controlled by the Federal Tort Claims Act, FTCA 28, blah, blah, blah. Under the FTCA, the United States is liable for the negligence of its employees in the same manner and the same extent as a private individual in like circumstances, blah, blah, blah. In determining whether a private person would be liable, the court must look into the law of the state. In this case, Texas law applies because that is where the alleged torts occurred. Under Texas law, trespass is a common law tort when another person enters another's land without consent. Generally, the United States enjoys sovereign immunity from suit unless it has specifically waived immunity. The FTCA provides for a waiver of the United States immunity from suit from those claims regarding injury or loss of property or personal injury or death arising from the negligent act or omission of any employment of the government while acting within the scope of his office or employment. The FTCA is a limited waiver of the sovereign immunity, blah, blah, blah. There can be no dispute that the United States and not the responsible agency or employee is a proper party defendant in an FTCA suit. In a section entitled "The United States as Defendant," the FTCA vests the district courts with exclusive jurisdiction of civil actions on claims against the United States for monetary damage. Emphasis in the original. The FTCA further states that any other statute authorizing a federal agency to sue and be sued in its own name is not authorized in action, blah, blah, blah. Thus, an FTCA claim against a federal agency or employee as opposed to the United States itself must be dismissed for want of jurisdiction. In other words, Vanessa's lawsuit against the FDA and their special agents failed because you cannot sue a federal agency or the employees. You need to sue the United States itself. The court continues to explain all the problems with Vanessa's claim. The federal defendants in the case at bar were all acting within the scope of their employment at all relevant time. They were sued for performing their jobs. Judge Libby signed the applications for a search warrant in his role as a United States judge. Special Agent Thorpe is the attorney in charge of the investigation for the United States Attorney's Office. Special Agent Miller is the agent leading the investigation for the A. Miller submitted the applications for a search warrant affidavit in his role as a special agent for the FDA. All acts were performed by the federal defendants within the scope of their employment within the federal government. Therefore, they are improper party defendants under the FTCA and should be dismissed with prejudice. Although the FTCA contemplates lawsuits against the United States in certain situations, here, plaintiff's claim against the United States should be dismissed. A pro se litigant must comply with the federal rules of civil procedure and the local rules for the Southern District of Texas. Local Rule 10 requires that the papers must have a caption, including the name and party designation of the party filing. Rule 10 FRCP requires that the title of the complaint must name all the parties. Rule 11 requires blah, 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 blah. So the judge here is basically explaining every single error that they committed in the filing of this claim. Finally, plaintiffs disregarded all the rules cited above. Nevertheless, the court gave plaintiffs adequate opportunity at the pretrial conference to state their name for the record, but they refused. They also refused in any way to explain the basis, factual or otherwise, of their cause of action against the United States. Although plaintiffs demanded return of their property at the pretrial conference, they refused to identify the property. Plaintiffs' failure to follow the rules of civil procedure and the local rules for the Southern District of Texas and Texas Rules of Civil Procedures are grounds for dismissal of their claim against the United States. Conclusion. Despite plaintiffs' disregard of the rules, the court gave them ample opportunity to correct their omissions and rescue their claim, including offering informa pauperis forms when plaintiffs asked the court to appoint counsel. Yet plaintiffs declined. Their refusal to answer the court's question, their nonsensical statement, and their total failure to articulate what their claim is leave the court no choice but to dismiss plaintiffs' remaining complaint against the United States. For the reasons stated herein and on the record, the motion to dismiss is hereby granted and the case is hereby dismissed with prejudice. And finally, if Vanessa does watch this video, which I hope she does, I hope that she learns from this failure and hires a real attorney because she is looking at substantial jail time for this FDA situation. I've been looking at similar cases of people selling mislabeled diet pills, as Vanessa did, and she's looking at a couple of years in jail time. For example, in May 2016, another guy who was doing the same thing as Vanessa got sentenced to 15 months in federal prison. And this is something that Karl Lentz might not have told you, but you will also have to forfeit all property and pay back all the money you made selling those pills. This guy, for example, had to return $679,000. So every single dollar you made selling those pills, you will have to pay back somehow. That's it. And that will probably mean you having to sell your house, selling your cars, and have to work for the rest of your life to pay back those fines and restitution. So please stop listening to Karl Lentz. He is not going to be able to help you. And he has shown that already in your case. You've been listening to him for 6 months, and you've already lost in court. And by the way, your house was recently put up for foreclosure sale. The Karl Lentz material help you with that? No. You will not win. By the way, a month after your failure in this civil case, Karl's stepfather was convicted for aggravated sexual assault. You know, if he can't win in his own personal life, he can't help his own family, what chance does he have of helping you? I really don't want to have to make another video in 6 months or a year saying Vanessa Gonzalez sentenced to X amount of years in prison. You know, I mean, I'll do it, and I'll laugh about it because you threw yourself in jail through your own stupidity. But I don't want to do that. That's why I'm trying to warn you not to listen to Karl. He cannot help you.